All right, let's talk more now with our legal guys about this case. Avery Friedman, a civil rights attorney and law professor in Cleveland. Good to see you. And Richard Herman, a New York criminal defense attorney and law professor, joining us from Las Vegas. Good to see you.
Hey, Fred.
Okay, so Richard, does Gavin have a strong legal case?
Well, he had a strong legal case when the Obama directive was in place, because his entire case is premised upon the discrepancy that arose as a result of President Obama and the administration's directive. The Trump administration has taken the Obama directive and thrown it out the window, so it doesn't exist anymore. And now the case is supposed to go to the Supreme Court. I don't think the Supreme Court's going to take this case, Fred. I think they're going to turn it back to the district court for more litigation. The Supreme Court likes to rely on district court decisions. There are none here. And I just don't think it's right for the Supreme Court, since the Obama directive has been terminated.
So then, Richard, how is Title IX either a tool in this argument?
That's the issue, Fred. That is the issue. Title IX protects the United States citizens from sexual discrimination. Does that also apply to gender identity? That's the sole issue here, Fred. There are arguments on both sides. Until the Supreme Court or Congress make a determination or a decision or a law on this, it's up in flux. So while the Obama administration said it's our interpretation of Title IX that it does protect gender identity, the Trump administration says, no, leave it to the individual states and the individual school districts to decide their educational policies. So you see, we have a major issue here, and it's a hard issue, and there's passionate arguments on both sides here. And George Takei from Star Trek stated that it's not about the bathroom like it was not about water fountains. There are moral issues here. There are issues to try to protect people's rights. And there's a short-term solution to long-term. The long-term is for the Supreme Court or the legislature to enact a clear law on this. Short-term, Fred, let's be realistic. It's like you have family bathroom, you have multi-use. Have a bathroom, a single bathroom that anybody can use. That's a short-term solution in the schools, and then let's litigate this in the courts and get a firm determination here.
So is it your view that states would be able to handle this alone? I mean, it would seem that potentially, even with state law, ultimately or potentially it will become challenged in U.S. Supreme Court, which will then involve the federal statutes on civil liberties and civil rights.
Yeah, and that's the whole issue here, Fred, is what does Title IX cover? Because there's nothing in Title IX that references gender identity. So people have to read into it, and they have to make arguments based on the intent of Article 9. And until the Supreme Court makes a determination on this issue, and the Trump administration wants to get Gorsuch in for that determination, until that time takes place, it's in a state of flux. The states will now do what they think is best under the cloak of supervising education and protecting the educational experience, and there will be more litigation. And that Grimm case, interesting to watch. It's on for this spring. We'll see if the Supreme Court takes argument on it.
All right, Avery Friedman, Richard Herman, always good to see you, gentlemen, and hear you, even if we don't see you, Avery. All right, thanks so much.